The situation in personal injury cases, I mean, it's so dramatized in terms of TV and what happens and what doesn't happen. But in establishing trust with the various stakeholders, the client, the police, the other side, the court, the insurance company, do you have certain protocols in place that you would adhere to? That, for instance, you know, that first letter to the lawyer on the other side, or the letter to the police officer, the letter to the insurance company, or the submission to the court? Are there certain protocols that you try to follow? I'm hearing you on the civility,
Yep.
but in terms of protocols and processes that you would want to put in place.
Well, especially with personal injury cases, you are informing all the parties that are necessary pretty early on that you've been retained, that you're investigating a matter, or that legal action might be commenced. Usually the parties involved are good to provide what it is that's necessary to move forward.
Do they do that in a timely way?
Not always, and sometimes we encounter problems where things move a little slower than we'd like. There's already a huge delay in all the steps that have to be completed because there are so many cases out there because of, you know, the workload that many lawyers face. Unfortunately, that's the reality of the situation. There is a delay in moving cases along. But you have to manage your time very well and manage your cases very well to be planned and organized in your practice, to make sure that you're following up with all of the parties involved, to make sure they're doing their part in moving things forward.
Tell us, if you will, in terms of your practice on the personal injury side, challenge isn't just organizing the file.
Yes.
It seems to me that it would just be horrendous in terms of all of the information you have to get from your client, but then all of the information that you have to get from all of the other parties.
Yes.
And keeping that in a sort of a logical sequence for the purposes of moving forward.
Yep. And so it's very difficult to keep all of that organized, but you have to have systems in place, and I have to say that the only way to do it is really to have help, assistance, and I'm fortunate in that I'm working in a firm where lawyers work together, they help one another. We have staff that is excellent and assists with those kinds of things. Everyone plays a different role. It's a lot of building a personal injury case is based on teamwork. And
that's fascinating.
It is very important because of the volume, the sheer volume of documents and information that you are trying to manage and present in an understandable way. Everyone is responsible for something, and I would say almost every member of the team has communication with the client. So the client knows there's not just one person working for them, there's a team of people working for them. And oftentimes they have an issue, they're not sure which member of the team to talk to, they're always talking to one member of the team, and that person is saying, here's who can help you with that. That's the most effective way, I think, to deal with the case, especially as it progresses through time. Different people will have different responsibilities.
So share with us in terms of your style of the case. I come in to see you, I've been involved in an accident, it's lower back, I'm in pain and suffering. When do you make the decision to sue or to try to settle?
Well,
or is that your decision?
Sometimes it's an ongoing evaluation. At every stage in a case, you need to evaluate the strengths and weaknesses of your case. And that changes over time because the evidence that you have in your possession might change. So like I mentioned, sometimes at the beginning of a case, you might hear what your client has said and you think this is this is a perfect case.
Golden
It's-
information.
Well, it sounds like it's easy to identify who's at fault. It's easy to identify what injuries have occurred, and it's easy to identify what damages the person has suffered as a result of the injury. But cases are never as clear-cut as you want them to be, and as time goes on, things get a little more complicated. So I try to stop at various stages in a case to reevaluate and advise the client about the strengths and weaknesses, because it's important that they understand too what
So
things might be
you do
lacking.
this evaluation, your strengths and weaknesses, continuously with the client?
Correct.
You just don't do it at the end, or?
Correct. And in some cases, when we evaluate a case before legal action has officially been commenced, we can tell the client, we kind of recommend this might be something you want to pursue, or we wouldn't recommend pursuing it for these reasons. If that's the case, then, if they choose not to proceed, or they're taking a recommendation not to proceed, then that might be the end of the road for us. But if they do decide, or we do think that we will recommend to continue, at that point we tell them what's ahead, what we'll need to build our case, and that we'll continue to tell them if they're, the strengths and weaknesses in their case at every stage.
Most cases are resolved, are they not, before they?
Most cases are resolved before trial, yes. But what a lot of people don't realize is from that initial statement of claim that's issued to commence the action until trial can be several years, several months or several years.
How do clients react to that?
A lot of them are in disbelief that it takes that long, but a lot of them don't realize the many stages and the many things that they need to go through before a case is ready for trial or even ready for settlement.
Tell the viewing audience the distinction between the trial and a discovery.
So a discovery is something that happens usually a little earlier on in the case, and it's the opportunity for all the parties to gather evidence on all the parties involved. So in cases like ours, oftentimes the person who is injured is being examined by the lawyer who represents the person who has been sued, or the insurance company who represents the person who has been sued. And on the opposite side, I will often be examining the person who is being sued, or if there are other players involved, sometimes companies, corporations, representative of those companies or corporations are examined. And our goal in that entire process is to fully understand the positions and the evidence that both sides have.
So there would be a statement of claim,
Yes,
there would be a statement of defense,
yes.
and then would it be set down for discovery?
Usually. In personal injury, I know they do it differently in different areas.
civil, yeah.
Yeah, but generally, we proceed to discovery after the statement of claim and statement of defense.
Is that when you make the decision whether to settle or not to settle?
That's one of the times where we stop and evaluate whether it's appropriate or not. Sometimes there are a lot of factors that go into deciding whether a case is, whether it's a good idea to approach settlement, or whether settlement is even possible. First of all, when you're thinking about having settlement discussions, it involves speaking with the other side. If there's willingness only on one side, you don't really have that opportunity. Sometimes there's information, crucial information that's necessary for a settlement that hasn't yet been, uncovered or agreed upon. And when that's the case, then, settlement negotiations have to be delayed. That happens often in situations where fault hasn't been determined. Liability is at issue between parties, and they want to proceed with examinations for discovery to shed some light on what happened. Sometimes it occurs when there's a big disagreement about how severe the injuries were or what damages were suffered at all.
Just take you back a few steps. You're preparing to meet with the other side.
Yes.
You have your client, I'm your client. Lower back pain, a lot of pain and suffering. So you're going to meet with the lawyer on the other side.
Yes.
How do you put together the agenda for that initial meeting? Do you do that through an email? If you do, what's normally in that email to set up the agenda for the meeting?
Sorry, do you mean with opposing
Counsel.
Usually when we have discussions, we kind of have like you said, an agenda, an idea of what we're trying to achieve. And what I usually like to do is highlight, make some notes, review my file, and ensure that I'm aware of what the strengths and weaknesses are of the case, and what I think is going to be an area of disagreement between myself and the opposing side. Once we get into those discussions with the opposing side, it becomes a little easier to understand what they take issue with, if we're going to be in a position to, talk actual settlement, whether there are some issues that we can resolve now and some that can be resolved a little later.
But do you actually have an agenda? Items 1 through 10, 1 through 4. We're going to discuss liability. We're going to discuss the expert's report. We're going to discuss what came out of the discovery.
A lot of times...
Is it that refined, or is it much more sort of, well,
it depends on which stage we're at in the case, but usually, yes, I like to take a complete look at the file. The reason for that is because when you're evaluating a case, you have to look at everything collectively. For example, you might look at your case and see the damages are evident, this person suffered great injury or is having a lot of difficulty moving on with their life, functional limitations, they need to be compensated for that. But we can't get to a discussion about about damages rather, if liability is going to be in question. So there are so many ways that the two influence each other, and also that various damages influence each other. I really try to look at everything before I engage in a discussion.
Can you just give us 90 seconds of law in terms of what do we mean by damages?
Okay, so
because I think there's different categories, correct?
Yes, there are different categories. So in different cases, general damages, meaning general damages we use as the term, most people think of it as pain and suffering. So the value for the injuries and the limitations that are associated.
It's $200,000.
Well,
poor back,
and,
poor back.
And it's very difficult, like I said, to quantify that, because when you're looking to an injury, it's not like a price list. It's not easy to say a broken arm is worth $50,000, but a broken leg is worth $40,000. Whatever people want to say, it's not that easy. It depends on not only the severity, but there are a lot of other factors that go in. How long the symptoms last, how old or young the person was, whether they've made recovery, what kind of treatment they need.
So that would be general damages.
That's general
essentially
damages.
Pain and suffering.
Right.
What other damages are out there?
Another big one is loss of income or loss of earning capacity. You're looking at if the person was working at the time of the accident, if now their injuries have rendered them unable to complete their employment. Maybe they're able to mitigate their damages in that area, maybe they're able to return to a different profession, but in certain cases, people are so disabled that they're unable to perform any type of employment, whether that be physical or emotional. So loss of income. Loss of earning capacity as well ties in a little bit to that. Say, for example, someone who is in the beginning of their career and had potential to really grow.
Is that what you would call special damages? Or is that a different category altogether?
No, special damages, that's right, yep. So special damages would incorporate the loss of income and loss of earning capacity. And with loss of earning capacity, it is a lot harder than a loss of past income, for example. If you're looking at someone who is earning a certain amount for several years, it might be a quick calculation, incorporating inflation and present value, that kind of thing. But when you're looking at someone's potential, there is...
It's kind of different.
It is very different.
Very
And
different.
sometimes we have to rely on experts for that, to tell us what is realistic, what's a best case scenario, what's a worst case scenario. So that's a situation where an expert might be useful. Other types of damages, inability to do things, everyday things. If the person is responsible for caring for another person, say a parent gets injured and is unable to care for their child, or perhaps an elderly parent, their ability to do things around the house. If that person was responsible for doing everyday things like laundry, dishes, cooking, cleaning, if they can't do that, they may need to rely on someone else to do it. Or they may need to hire someone if they don't have anyone available who can do those things for them. And also other considerations, recreational, leisure, social things that they used to do before that have been impacted. A lot of people who...
What about out-of-pocket expenses?
Out-of-pocket expenses is another thing. Some people, have to spend because they have no other way of funding their treatment or the things that they need. So they're paying out of pocket for those, and they should be reimbursed.
Now, in dealing with all of these stakeholders, the client, the police, the lawyer, the insurance company, how do you deal with deception?
Well, there are various ways to approach it. I think with opposing lawyers, it comes into what I had said about reputation. You have to proceed on the assumption, I usually do, that everyone is acting in good faith, that everyone is, while they're acting for their client's best interests, they're also acting in a courteous, civil, respectful manner. When I've been placed in a situation where I can no longer trust the other side, or I don't feel that I can engage in a meaningful discussion with them, that really hurts the relationship and slows things down. Nonetheless, you have to work towards repairing that, because moving forward...
But what do you do, though, with that person that is being very deceptive? Do you put everything in writing from then on? Can you trust them over the phone? Can you send them an email and expect that they're going to answer honestly?
Unfortunately, there are some things, once you've got that, there's been a break in the trust, I think you do need to be extra cautious, especially in our profession. You do usually want to make many of your communications in some written form, just to make sure that there are no misunderstandings or there is no possibility of misinterpretation or deception. So once you've confirmed things with them, putting things in writing is a good idea. But also making it known to them that you do feel that there's been a break in trust. When someone has done something that you think has really, harmed the relationship, it's, I think, important to let them know that, so that they know that their actions aren't without consequences.
So, next question. How do you deal with difficult people? Not deceptive people,
Yeah.
but people who are just difficult beyond comprehension. How do you deal with it?
Well, it's funny that you say beyond comprehension, because I would say the number one way that I deal with difficult people is to try and understand where they're coming from. I think that they're being difficult, as I perceive it, perhaps, for a certain reason. Maybe because they feel unfairly treated, or because they think that they are voicing concerns that aren't being addressed or aren't being heard. So what I try to do in those situations is really understand where they're coming from and why, and then address those. When I'm speaking with clients who are feeling like the process is treating them unfairly, sometimes all it takes is a conversation for them to understand that, and for me to explain why things are going the way they are. And with opposing counsel, if that's the case, then you have to understand why they are acting a certain way. It might be because they're being instructed by a very difficult client. So empathy comes into play here.
So how would you measure your listening skills? Do you think they're important
I think
in
they're
the process?
I think they're very important. You want to make sure that you don't get so wrapped up in your strategy and your ideas of a certain case that you forget to consider where everyone else is coming from. I think that's one of the most important things that you can do in our profession, is to listen, empathize, understand, and work from there.
So it's a pretty important piece of the process, the listening skills.
Absolutely.
Are you good at it?
I like to think so. I am working on it every day. I think, like I said, it pays to listen. So you will find that your job is easier, that your results are better if you are listening to the parties involved. The process just moves along smoother.
You are wise beyond your years, because in law school, we are really taught to talk.
Yes, that's true.
We're not taught to listen.
Yeah.
But you have seemed to have understood that, and this has become part of your DNA, which is good listening skills.
I think that comes from working so closely with clients, especially being on the plaintiff side. While other lawyers might be able to identify their position and how they're feeling and voice those positions and feelings, a lot of the time my job is working with people who haven't had much experience in the legal process and are feeling a certain way or want to voice their positions but don't know how to put that into words. So it's my job to work with them to figure that out.
Very good. From your perspective, what are some of the qualities of a good negotiator that you've seen in your experience? You've seen other counsel, you've seen judges, you've seen police, you've seen insurance, plaintiffs, others. What are some of the qualities that you have taken to be a good negotiator in your particular profession?
Well, I would say creativity comes into play quite a bit, and that's something I've seen a lot.
Could you give us an example of that?
Yeah. You know, when you enter into any negotiation, you have a list of your goals, what your priorities are, and you're also wanting to think about what the other parties list as their priorities. And I think in school they always talk about the fact that, you know, if you're sharing an orange, one person might want the orange and one person might want the peel. Unfortunately, I very rarely come up with a negotiation where the solution seems so evident. But if you are creative, sometimes you can work out terms that everyone is only a little bit unhappy with. And I say that because I've heard many times people say at the end of a negotiation, the way that we know it's been a successful, there is a successful result is if everyone feels a little bit unhappy. No one wants to end a negotiation thinking that they've lost all of the things that they came in to get, but they also will never feel as though they've won everything. All the parties need to compromise, be flexible, and walk out with something that they are willing to accept and which meets a lot of the things that they're looking for, if not all.
Any comments with regards to the civility of our bar here in Ontario? Do you find that civility is now back in vogue? You will recall that several years ago, the Law Society of Upper Canada had to initiate a commission that traveled the entire province dealing with lawyers on the issue of civility. Do you find that it's coming back to play?
I do. I think in law school it was discussed quite a bit, but I don't think people realized how important it was until they really got out into practice. And like I said, for me, I have a constant reminder that it's important, mainly because of the small community and the fact that I encounter the same people over and over again. You learn very quickly how important it is to be civil. And in my eyes, you garner respect that way. If you want to be difficult, disrespectful, you might think that you're a tough negotiator or a tough lawyer, but it doesn't usually sit well long term.
The this aspect of our profession, civility is not only in the personal injuries, but it carries on in all sorts of facets of our life as lawyers. And it's been my experience that if my behavior is such, more than likely the other party will duplicate my behavior.
Yes.
In other words, if I'm edgy, if I'm nasty, if I'm overly passionate, well, the other side is probably not going to take a back seat.
Right.
So it's important for me anyway, in terms of dealing with parties on the other side, that I have to check my behavior
Yeah.
if I want to have that civil behavior from the other party. Have you found that way as well?
Yes, definitely. And I think, like we spoke about before, even in situations where you don't find that the other side is reflecting your behavior, I think it's important to maintain your own sense of civility.
Have you had any opportunities to deal with the media on any of your files?
I haven't really. That's something that I might look forward to in the future, but I haven't really had the opportunity to experience much of the media in the past.
Because they'll come knocking.
Yes.
They'll come knocking. And I think that's where your civil background will come into play. Look, one of the final questions that we put to all of our guests, and we want to thank you for being our guest here today, is that in view of your experiences, you've got 2 degrees from 2 prestigious universities, both in the civil and the common law. You've been practicing. You're in the personal injury type legal profession, which is exciting, demanding. What sort of advice would you offer to a graduate of Ryerson University, a young person trying to get a job or to get a career that they'd like to be happy with?
Yeah.
Some go on to get other degrees, but what are some of the things that you think that they should look out for as they approach the working world?
I think it's important to be open-minded. Once you've studied something in school, sometimes you can have an idea about what kind of position or what kind of field that you think you would like. But you would be surprised in practice what kind of things you actually enjoy and what kind of things you're good at. So I would say that my advice would be to give everything a try. And after, giving things a try, if you decide that you're better suited for one thing than another, then that's fine. But if you discount certain aspects of an occupation or a field right away, you might be missing out on something that actually fits your personality, your education, your skills, and I think that's an opportunity lost.
Very wise, very wise. Look, on behalf of the Ted Rogers School of Management, the faculty at the university, and the students at Ryerson, I want to express to you our appreciation for joining us today, giving us your insights as it relates to the negotiation process, and for sharing with us some of the insights in terms of the personal injury side of the profession, because that's probably one of the hot topics that are out there, is personal injury.
Yes.
So on behalf of all of us, thank you very much.
Thank you very much for having me.
Thank
It was a
you.
pleasure.